And Your Honor, we asked that the court address this case because it was a reset jail jury, and the case had not been addressed. So we asked to have it brought back to address it.
It was reset jail jury from SAP before?
Correct. In January of 2025. Which is why we're asked, which was why we brought it back.
And it didn't make it to the division? I'm just confused what happened.
It went to the division. It did go to the division. The defendant had plea and arraignment February 19th of 2025.
And it's back here.
Right. The arraignment was before Judge Mather. And the case is in Judge Mather's courtroom.
Okay. I'm just confused why it's back to me, Ms. Falk. Maybe help me here.
So the defendant has now been in jail for, let's see, just to pull this up for Your Honor.
I got it, 121 days at least.
That is correct, on a criminal trespass.
Okay.
And the state just wanted to give the defendant an opportunity, if he wished to enter a plea, to enter one.
I doubt that's going to happen. All right, Mr. Harris, your case is 24 CR 008301G. You're charged for criminal trespass in this case. I understand that you have declined the services of the Public Defender's Office. It's my recommendation that you allow them to assist you today. Do you still wish to represent yourself?
Yes, ma'am.
All right. I'm going to allow Ms. Falk to put the offer to resolve this case onto the record today to see if you wish to plead guilty. So we're going to go forward with that. But first, do you understand, you do fully understand your rights today, including the right to an attorney?
Yes, ma'am.
Okay. All right, Ms. Falk, the offer in this case is?
The offer is time served, Your Honor, which would release him effective today. The state's recommendation is based on...
Buckle up, guys, because this opens with the return of a self-styled sovereign citizen who truly believes the country belongs to him. Right out of the gate, the narrator sets the stakes, his past jail time, his warped worldview, and the rare chance he's been handed to walk free. It's a sharp setup that makes one thing clear. We're about to watch confidence crash headfirst into reality, and it's not going to be subtle. Alright, guys, now the court starts laying out the facts. Dates, custody confusion, and then the jaw-dropper, 121 days already served on a misdemeanor trespass. The state makes it painfully simple. Time served, instant freedom. All he has to do is accept jurisdiction and plead guilty. This is the off-ramp from chaos, the moment where logic could end everything, but logic isn't his strong suit.
On the fact that the defendant has been in custody for 121 days, this incident happened December 25th of 2024 at the Greyhound bus station at 232 Forsyth Street Southwest in Atlanta. The defendant officers were called out to that location because the security guard had asked the defendant to leave several times. He refused. He stated he was a sovereign citizen, did not need to leave, and the officers, after asking several times, finally took him into custody.
Understood. Okay, so Mr. Howard, do you wish to take a plea today to resolve the case? The state is essentially offering to close the case based upon the time you served in the Fulton County Jail. However, they are asking you to plead guilty, and there were certain questions and representations you'd have to make to do so. How do you wish to resolve your case today?
I'll plead guilty.
You would like to plead guilty?
Yeah. It wouldn't matter either way, correct? If I did not plead guilty, like the first trial, pre-trial.
Okay.
Alright, guys, this is where everything wobbles. He agrees to plead guilty, then immediately tries to undo it with sovereign word salad, acting like guilty and not guilty can somehow coexist. The judge calmly explains these are legal opposites, not menu options. You can feel the tension spike. Freedom is inches away, yet every sentence out of his mouth threatens to blow the deal apart.
I'm going to ask you some questions. I'm going to place you under oath. Please raise your right hand. Do you affirm that the testimony you give today be the truth to the best of your knowledge?
Yes, ma'am.
All right. I'm going to have to ask you some additional questions because you're representing yourself. Again, you are declining the services of the Public Defender's Office. Do you wish to have their assistance? I recommend that you take it.
I mean, I have paperwork showing, proving my sovereignty, ma'am. But I mean, if it doesn't go towards the jurisdiction, I'll just, go with the best option.
Okay, so the answer is no. You don't want them to help you.
So, ma'am.
Okay. Do you agree that the state has the proper defendant, being you in this case?
Yes, ma'am.
Do you agree that this took place in Fulton County?
Yes, ma'am.
And do you stipulate or, in a sense, agree that the facts that's just put on the record are what happened that day? You may disagree slightly, but for the purposes of this plea, do you agree that that's what happened?
Yes, ma'am. And I had for that day I had a compensation on courtesy transportation, not by just the officer that didn't arrest me. It was another officer that took me in and said he was going to pay for my bus ticket, but also the bus driver for helping out one of the people on the bus, giving up my seat and everything of that nature.
Okay. Are you under the influence of any drugs or alcohol that would affect your ability to understand this proceeding today?
No, ma'am. I don't smoke or drink. If I'm
Okay.
out, I drink wine, but that's it.
All right. Did anyone promise you anything in exchange for taking a plea?
No, not at all.
Okay. And you don't feel forced to take a plea today, do you?
No, I'm not forced at all.
Okay. And you, again, are declining the services of an attorney, even though you understand that you have a right to an attorney at this proceeding.
Yep.
And you understand that you're giving up your right to trial as it pertains to this matter?
Yep. There ain't no point in going to trial for criminal trespassing if I already time served. So,
Okay. And you're giving up your right to have the state prove this charge against you beyond a reasonable doubt?
no, ma'am. I ain't get up no rights.
Oh, if you would have to give up your right to take a plea. If you don't want to take a plea and we proceed to trial, essentially I'm asking if you still want a trial. Do you still want a trial on this?
No, go ahead. I'm fine with that. I'll do trial.
Okay. And you understand that taking a guilty plea may affect other aspects of your life, such as an open case if you have one, any probation issues, anything of that nature?
No, ma'am.
You don't understand that?
No, I understand it. I'm agreeing with you.
Okay. All right. As to the charge of criminal trespass, Mr. Harris, how do you plead?
Guilty.
I accept your guilty plea. Is there anything additional, Ms. Fault?
No, Your Honor.
All right. Essentially, the time you've served in the Fulton County Jail should close your case. All right. Best of luck to you, Mr. Harris.
I'm saying I get all my information.
Okay. And will somebody at the jail be able to help him sign the paperwork? I'm not sure who, but will somebody, because he won't be able to get out if we don't have any documents.
Guys, now we're deep into the plea process. Despite rambling answers and strange justifications, he technically checks every box. Jurisdiction is acknowledged, rights are waived, and the judge finalizes the plea with time served. This is as generous as it gets. Case closed, release approved. The system practically hands him a reset button, bending over backwards to move things along cleanly.
Who do we have in courtroom 2?
Position 9, Mr. Harris.
And this is your case, Mr. Chitara?
Yes, sir.
Mr. Harris, no, this isn't my case, Your Honor.
Okay.
I understand he wanted to go pro se.
Oh, that's right. Yes, yes, he wants to go pro se.
okay. Good afternoon, Mr. Harris. You have a right to remain silent. You have a right to have an attorney represent you at these proceedings. It's my understanding that although we have offered you the assistance of a public defender this afternoon, you wish to proceed without their assistance. Is that the case?
Yes, sir. I'm a royal and a sovereign citizen.
Okay. Mr. Harris, you've been charged in case 25 CR 002224Y with criminal trespass. Is there a history, Mr. Howard?
7, resident of Tampa, history out of Florida, Pennsylvania, and Maryland. 2024 theft, 2024 trespass arrest, 2024 probation, 2023 DUI. He got time served last week in SAP and was released Friday. So he's back.
Alright, guys, here comes the twist nobody asked for. The narrator reveals that just 3 days after being released, he reoffends and ends up right back in court. New case, same behavior, same location. Suddenly, everything you watched before feels less like redemption and more like a brief intermission before the inevitable sequel no one wanted.
Okay. Ms. Melchizedek?
Um, yes, Your Honor. This incident is from yesterday, April 28th. The location is the Greyhound bus station located at 232 Forsyth Street Southwest, Atlanta, Georgia. Officers spoke with two Greyhound security officers who explained that the defendant was criminally trespassing and refusing to leave the bus terminal. The officer approached the defendant, who the officer recognized from a similar interaction that he had with him on April 27th, 2025. The defendant was sitting in a seat of the Greyhound bus terminal, refusing to get up. The officer asked him what was going on. The defendant stated that he was about to ride the bus to go home. The officer explained to the defendant that he had already been criminally trespassed from this location on December 25th, 2024. The defendant told the officer that he's a royal and sovereign citizen, and therefore he cannot be trespassed from anywhere. The defendant was arrested. Your Honor, the state's and he also pled to criminal trespass on April 24th, 2025, during the SAP calendar. In that case, is 24 CR 008301G. It was also from the same location. Your Honor, the state's recommendation is a $1,000 surety bond. Stay away from Greyhound bus station at 232 Forsyth Street Southwest, Atlanta. Social service visit to determine if a VHET is needed. No alcohol, drugs, or weapons while on bond, and that is all for the state.
Y'all can say anything, Merle?
Give me a second. Hold on.
All right, no problem.
Yes, Mr. Harris, you do have a right to remain silent. Anything you say can be used against you. With that said, what would you like to tell the court?
Well, as a royal, my duties here was to work directly with the NRA, and I have a corporation that I deal with, which is a Big Step Inc. that I own under my sovereignty name, which is Tyrone Harris. I have cybersecurity and security that's implemented in throughout the states that I have to come by and also deal with. I have eminent domain, which is any private property that's in use. I can use it for public use for any type of business. And I have non-monetary conditions in the state of Pennsylvania. That's any cash, any currency of the U.S. dollar doesn't apply to me because the currency that I use is gold and silver that's already implemented in the banking system, the state treasury fund of that nature. And I have sovereign immunity also, so all past charges are charged back, just like my case that I just passed before. I served 4 months in about a week and 2 weeks, and I already pled not guilty for the first pretrial because I had a proof of a ticket and a proof of one of the officers saying they was going to compensate a ticket for me to go back to Tampa, Florida to deal with business. And also, that's
Mr. Harris, I think I understand. So thank you, sir. I appreciate that. As for this matter today, it's going to be $1,000 good bond. Stay away from the Greyhound bus station, and no drugs, alcohol, or weapons while out on bond. You'll have the opportunity to present your case at your next hearing.
All right, guys, this stretch is peak sovereign performance. He crowns himself royal, claims immunity from trespass laws, and rambles about imaginary financial systems and eminent domain powers. The judge listens without reacting, then responds with something far more real: bond terms and stay-away orders. It's fantasy versus fact, and the courtroom isn't buying what he's selling.
Sir, good luck to you.
Is there any way I can get an expedited transportation back to Tampa, Florida? If there's if I can't use a Greyhound bus station to go back, even though I have travels to do that, so to do that.
What I would suggest to you, Mr. Harris, is that for your next hearing, that you might want to consider letting the public defender speak on your behalf and help you get some of those arrangements. That might be a possibility if you can have someone, if you can get those arrangements made. So, but that's up to you.
How about you?
Yes, Position 13, Tyrone Harris, and he's going pro se.
This is State versus Tyrone Harris, case number 25 CR 002224Y. Mr. Harris is accused of criminal trespass from April 28th, 2025. Mr. Harris, you have the right to remain silent. Anything you say about the facts of your case during the course of this proceeding, your statements can and will be used against you. You have a right to an attorney. If you cannot afford one, one would be appointed to represent you, and you'll be represented by an individual who understands the criminal rules, procedures, and the law. However, if you choose to waive your right to be represented by counsel and choose to represent yourself, then you are responsible for understanding the rules, law regarding the crime of which you've been charged, and that you are responsible for any legal decision and its impact upon your circumstances, including your freedom, your job, any professional licenses you may have, or any other open cases you have. I understand that you want to represent yourself. Is that correct?
Yes, ma'am.
Do you understand the consequences of representing yourself?
No.
I'm sorry, do you understand?
Yes, ma'am.
All right. You had your first appearance on April 29th of this year, and you received a surety bond of 1,000. Good bond with requirement to stay away from the Greyhound bus station at 232 Forsyth Street. How would you like to proceed with your case today? Are you entering a plea of not guilty and requesting a trial? Or have you considered a plea offer and want to enter a plea in exchange for a recommended sentence?
I'm trying to get what you're trying to say, because also I had a criminal trespassing. I spent 4.5 months before that last criminal trespass I just had, and I already had a surety / guarantee bond, which I have now as a royal.
Even all right, guys, this is where patience runs out. The judge spells it out plainly. 4 months locked up, released, then arrested again within 3 days. Requests for leniency go nowhere, signature bond is denied, and the options narrow fast. Trial or plea? This is the exact moment his behavior catches up to him and starts costing real freedom.
So again, I'm asking you, would you like to plead not guilty and have a trial, or would you like to consider a plea offer from the prosecutor?
All right, what's the plea? What's the plea?
Mr. Scirocco, what is the plea offer?
It is 12 months to serve 22 days, credit for time served 11 days. This is for position 13, correct, Judge?
Correct.
That is from April 28th, 2025 to present, for him to complete behavioral health evaluation and any recommended treatment, and for him to stay away from the Greyhound bus station located at 232 Forsyth Street in Atlanta.
All right, Mr. Harris, you'll be placed on probation for 12 months.
I'm not from Atlanta. I'm a sovereign citizen. I'm a royal sovereign. I got paperwork.
Well, even if you're a sovereign citizen or a citizen of the moon, you'll still be placed on probation.
Understandable. Well, if I have non-monetary conditions, which I use the state treasury fund to pay for everything, what does that entail?
I don't understand the question.
I have non-monetary conditions in a state that I've never been into. What does that entail for other jurisdictions that follows the Commonwealth state?
I don't understand the question, so I don't know how to answer it. The only question I want answered is whether you want to have a trial or whether you want to consider this plea offer. All right, we will return to your case. You may have a seat and ponder the question. Next case, please. Mr. Harris, have you reviewed the paperwork for your plea?
I haven't received paperwork, but I'll plead not guilty.
You have not received it?
No, ma'am.
Okay.
Last time either.
Your Honor,
He never said he was taking a
plea. That's a sovereign citizen.
Oh, okay. So, that's right. Sorry, Mr. Harris. I left you with the last question was whether you want to consider the plea offer or whether you like to plead not guilty and have a trial. So have you made a decision?
I plead not guilty.
Okay?
I never seen paperwork, so
No, you won't see paperwork. I thought you were considering a plea. All right.
yes, man. The last 3 trials I haven't received paperwork.
Okay. So, Tyrone Harris, case number 25 CR 002224Y, is accused of criminal trespass from an incident date of April 28th, 2025 in Fulton County, Georgia. The criminal trespass is a misdemeanor offense. Mr. Harris, would you like me to read the accusation, or would you like to waive a reading of the accusation?
You can do what you do, man. I appreciate you.
That doesn't answer. Do you want me to read the formal accusation, or do you waive a reading of the accusation?
You can read it for me.
Repeat.
I said you can read it for me.
This accusation submitted by the Solicitor General of Fulton County was filed on April 29th, 2025. And with respect to the accusation, the Solicitor General of Fulton County, Keith E. Gamage, does accuse Tyrone Harris with the offense of criminal trespass in that on or about April 28th, 2025, in Fulton County, Georgia, the accused did knowingly and without authority enter upon the land of Greyhound Bus Station located at 232 Forsyth Street in Southwest Atlanta after receiving prior to such entry notice that such entry is forbidden by the owner and authorized representative of the owner on December 25th, 2024, in violation of Georgia law section 16-7-21. Upon this accusation, you have decided to enter a not guilty plea. Upon your entry of such a plea, the case will be reset for a trial. You have the option of either considering a jury trial or a bench trial. At the time of the trial, the prosecutor has the complete burden to prove the charge against you beyond a reasonable doubt. If the prosecution does prevail and overcome your legal presumption of innocence, you could be convicted of this offense and face a possible penalty of up to 1 year in prison and or up to $1,000 fine. Given this information, how do you plead?
I plead no contest, not guilty.
All right, no contest and not guilty are completely diametrically opposite pleas. No contest is tantamount to being a guilty plea and being sentenced.
Well, not guilty.
So this is a not guilty plea. Your case is going to be reset for trial.
All right, guys, this might be the ultimate cell phone. He can't settle on a plea, claims paperwork conspiracies, and somehow tries to plead not guilty and no contest at the same time. The judge explains basic concepts over and over as frustration builds. Eventually, the court resets the case for trial, sealing consequences that stem entirely from his own confusion.
Jail jury, please be prepared to address the issues at trial and to represent yourself unless you choose to hire an attorney, or you can reach out again to the Public Defender's Office for representation. Thank you.
Okay, so
This, and what number did you say that case was?
add on 3. Actually, I'm sorry, it's just 3 on the regular calendar.
3 on the regular. Okay, thank you. This is State versus Tyrone Harris, accused of criminal trespass on May 25th, 2025. His case number is 25 CR 2953Y. Mr. Harris, you have the right to remain silent. Anything you say in open court about the facts or circumstances surrounding your case, also any circumstances involving any other open cases, your statements can and will be used against you in the treatment of your case. You have a right to an attorney. If you cannot afford one, one will be appointed to represent you from the Public Defender's Office. If you choose to waive your right to public counsel, then you have a right to hire your own attorney at your expense, or you can choose to waive your right to counsel and represent yourself. But please keep in mind that if you choose to represent yourself, you are responsible for all legal decisions. You are responsible for understanding the law, the rules, and the procedures as how they apply to the facts of your case and how it may have an adverse impact upon your freedom and any other open cases you have. So, courtroom 2, please unmute. Mr. Harris, given this information, would you like the services of a public defender counsel?
No, ma'am.
All right. Do you choose to waive your right to counsel?
No, ma'am.
Well, are you planning to hire your own attorney?
No, ma'am.
I'm sorry, repeat that.
No, ma'am. I'm not gonna hire an attorney. I'm representing myself, and I'm not gonna waive the counsel.
So you are waiving your right to counsel and representing yourself?
Okay, sure. Yes, ma'am. I'll waive my right to counsel. Too.
Okay. So you are charged with criminal trespass from an incident date of May 25th, 2025. You also have an open case, 25 CR 2224Y. Anything else, Ms. Hardy?
No, Your Honor, that was it.
All right, thank you. Mr. Nixon, what's the recommendation for Mr. Harris?
Yes, Your Honor. For Mr. Harris, it looks like the state's going to request a $2,000 surety bond for the criminal trespass. Occurred May 25th, 2025. The officer responded to the B building lobby in reference to a male refusing to leave the premises of the Georgia World Congress Center. And upon arrival, the officer met with Officer Ruffin, who stated a male later identified as the defendant was escorted from the B hall to the registration booth by a floor lead. The MomoCon safety staff member told Mr. Harris he needed to purchase a ticket for that day's event. As a pass he currently had was for Saturday only. It is unknown how Mr. Harris acquired an NRA badge or the MomoCon badge. Mr. Harris was arguing back and forth with them and stating he was told by the director that he could be accommodated for a ticket for that day. Ms. Harris was advised there was no accommodation for badges. Now, the defendant refused to buy a ticket, and the officer told him that he didn't want to buy a ticket. He would leave for the premises. Lieutenant stepped in and spoke with Mr. Harris, advising him of his options. He still refused to leave, even stating, "I'm not leaving." So Mr. Harris was placed under arrest. I've counted Maryland criminal history, 2024 criminal trespass arrest, 2024 theft arrest of Pennsylvania, criminal history, 2024 theft of services, and Florida criminal history, 2023 DUI, and 2023 probation violation. Defense has an open criminal trespass from the Greyhound bus station. The defendant has a guilty conviction for criminal trespass and received credit for time served for 121 days. The state is asking for a stay away from the incident location, no alcohol, drugs, or weapons while out on bond.
Okay. Mr. Tyrone Harris, the state is recommending a surety bond, and also I understand that you are scheduled for trial on June 10th for your underlying trespass case. What's your argument for bond?
I'm a royal, ma'am. I have authentication to show you. If anything, I have proof of that. For that case that we're talking about right now, Mark, the director, he does the checks and balances for that Comic-Con or that event that was going on. He was gonna upgrade me to a pass. The dude that actually was trying to say that I was lying or whatever, he's lying. The McDowell, the lieutenant, also knows about the information too. So, I mean, I have eminent domain. I can't explain it even more. I can't be arrested, but I'm only here just to prove my innocence and prove who I am. Mansa Musa the first.
All right. There was probable cause as sworn to by a law enforcement officer before a magistrate judge who made a determination as such and issued an electronic warrant. So the first tenet of detention has been satisfied. The second tenet of detention is under the ALA factors of whether you qualify for either a signature bond or whether you qualify for the surety bond or a cash bond. Given the fact that you have an underlying case for criminal trespass, you were recently awarded a signature bond on May 21st, 2025, and now you're right back in jail within a span of less than 3 days. So given the likelihood that you will reoffend, you do not qualify for a signature bond. For this new charge of criminal trespass, your bond is going to be $2,500. It's a surety bond. You have to stay away from the entire Georgia World Congress Center. And your next court date is June 10th at 9 a.m. We will let Judge Edie know that you are currently in jail unless you make bond. And if you do make bond, make sure you comply with the conditions of this bond order and make sure you show back up in Judge Edie's court.
Right, guys, welcome to the third act. Another criminal trespass charge hits the record, this time involving an event venue, fake credentials, and refusal to leave. His multi-state history is read aloud, painting a clear pattern. With non-stop reoffending on display, the judge shuts down any hope of a signature bond and raises the pressure even higher.
For your jury trial on the same day, June 10th.
Okay, no problem, but I have non-monitoring conditions. Also, if you read state, Tyrone Harris versus State of Pennsylvania. So when you actually read the case, you have to read the conditions that I have that goes with it.
I've read your cases and I've read the conditions set by Judge Edie, and that is sufficient for the bond hearing at the present time. If you have anything else to address, I highly recommend that you draft a brief and file it with the court.
It's already in the system. That's what I'm trying to tell you. I'm only here doing this so I can show proof of who I am. It's not just to keep coming back to criminal trespass.
What about position 26, Tyrone Harris?
Judge, this case has been disposed of in, I believe this is Division E. That would be Judge Morrison. Is it E? Is that correct?
It was Edie, and it was a dead docket, Judge, on the 10th of this month.
Okay. Thank you.
On your honor, position.
Was that for, are you saying, was that for both cases or was it just for one of them?
It was for both.
Both cases.
Okay.
Guys, this is the final unraveling. He launches into one last royal-style speech before the court cuts it off completely. The narrator explains the dead docket outcome, making it clear this isn't a win, just a pause that can snap back instantly if he repeats the behavior. And that's the end. Like, subscribe, turn on notifications, and we'll catch you in the next one.